Hello and welcome to Tactical IP Decisions. My name is Doug Schelling. I am a member here at Frost Brown Todd, and I have a presentation today that will be useful regardless of what area of business you are in. This webinar is brought to you by FBT Tech. Please visit fbttech.com for current and trending issues regarding technology and law, as well as previous webinars which have been presented in the area of technology. This webinar will also be available at that website. Due to the large number of participants in today's webinar, we will not be able to open the phone lines for questions. However, there is a software package on your desktop which allows you to submit questions, which I will then receive, and will be able to address those questions, some as we go through the presentation and some at the end of the presentation. So I have been practicing intellectual property law for over 15 years. I have a PhD in cellular and molecular biology, but my practice has been far more diverse than that. And what we're going to talk about today are many different industries, many different technologies. And also I want to remind you that this seminar is for educational purposes only. It is not intended as legal advice and should not be relied upon as such. Certainly, if you find yourself in need of an attorney, please seek advice of counsel to review the particular set of facts that you have questions about. So, with that said, we will take a look at the presentation. The roadmap for today is presented here. We're going to take a quick look at, what the results of ignoring intellectual property might be. That if you have not had a proactive strategy up to this point, that might be the strategy that you have been using. We'll then take a look at the scope of various intellectual property protections. We'll take a look at some of the action that's needed initially in order to protect an intellectual property asset. And we'll also take a look at how many patents your company should have, when a state trademark registration is sufficient, and what the future of intellectual property assets looks like. What types of companies need intellectual property strategy? Basically all. If you're a large company, if you're a small company, every company that's selling a product or rendering services has at least one piece of intellectual property. And, the industries may dictate how much intellectual property is relevant to your company. Here are some examples of industries in which intellectual property is important. Again, just a laundry list, and it varies from industry to industry. Some more highly regard intellectual property than others. But again, the point is all companies, all industries have needs for intellectual property protection. So we need to be tactical with our future intellectual property decisions. We need to employ some strategy, and that is what we're going to be talking about today. So why do we want to build an intellectual property strategy now? We want to do that so that we're well positioned to make future intellectual property decisions, because future intellectual property decisions will be made on short notice. There are going to be times when you may only have 2 or 3 days or have to make a decision on the same day. relevant to some intellectual property that you've got. Your future IP decisions will provide you the best available protection, and so it would make sense to have a strategy in place before those questions and those decisions need to be made. And your intellectual property decisions will likely allow you to reach your goals, whatever those are. You may be looking to sell a company in short order. You may be looking to practice the company, continue the business of the company for many, many years. So the first topic we're going to talk about is ignoring intellectual property assets, risks, and rewards. The rewards are short-term, those being the benefits of not paying filing fees, not paying attorney's fees. Those benefits are very small, and the dollar sign shown next to rewards is intentionally small to point out that these are not major cost savings. And for reasons we'll discuss, really ignoring intellectual property is not a suitable strategy to have. This is a slide we're going to come back to after we discuss some of the intellectual property basics. The risks involved with ignoring intellectual property assets include missing opportunities, being less than properly positioned for success, and allowing messy circumstances to unfold, those being costly to correct or clean up. So it's really a situation where you can pay me now or you can pay me more later after something bad happens. And so let's talk about why even bother protecting intellectual property assets. And the reason we do this is to gain an advantage over our competitors, exclude our competitors from taking certain action. We can actually control the conduct of our competitors if we have our intellectual property portfolio in hand and properly protected. Secondly, that intellectual property portfolio can be leveraged. You can borrow money from a bank. You can do other things to take advantage of the intellectual property. And it adds value to your company. If you are looking to sell a company, investors are going to want to have a comfort level that intellectual property has been taken care of. And if you walk into a meeting and you've got patents on the table, trademark registrations on the table, copyright registrations on the table, the apparent value of the company may well benefit from that. So shown on the screen are types of intellectual property. These are the four main categories. I'm not going to talk in depth about them right now. I just merely want to bring those up so that you have an understanding of the topics that we'll be talking about today. Intellectual property, when it comes to registering it's a jurisdictional animal. And what I mean by that is each jurisdiction that you're in has its own patent system, trademark system, or the like. That said, there are also multinational systems. Large entities that have intellectual property throughout the world find themselves wanting to file a patent application or trademark application in 15 to 65 different countries, which would mean many languages, many forms of currency. And so those multinational systems are out there and available for those circumstances where registration in many countries is desired. Normally, it's going to be a situation where the national systems will be made use of. And this is important to understand, because if you protect your intellectual property in the United States and then you become aware of a problem in China or Japan or elsewhere, just have an appreciation that your registrations are jurisdictional for the particular country of interest. This is the first of the four main categories. A patent is an exclusive right, and it's important that we understand you have the right to exclude others based upon obtaining a patent. This does not necessarily mean that you have the right to practice the invention itself, and we'll talk about that in a minute. But you have the right to exclude others from making, using, selling, offering for sale, importing the invention into the United States. And typically, when a person talks about a patent, we're talking about a utility patent. There are actually several different types of patents out there. Plant patents for various plant species. Design patents are patents directed towards the protection of what something looks like, the ornamental characteristics, whereas the ordinary patent, utility patent, is based upon protecting some utilitarian function. So an example would be a salt shaker, a cylinder having a plurality of openings in the top, which when inverted delivers a substance. That would be a utility patent. If you had a salt shaker with some design elements on the exterior of it, the design patent is going to be a situation where literally what is filed are drawings of the four sides, the top, the bottom, and the claim language says you claim that which is shown. So an example of the exclusive right is shown here. Let's pretend that patent A has claim language that is represented by the blue oval. And let's say that's for the invention of windshield wipers on a vehicle. An improvement to windshield wipers would be intermittent windshield wipers. It's only drizzling. I only need to wipe the windshield once every 5-10 seconds. So the improvement, let's pretend, was applied for and received patent B. So the scope of protection outlined by the claims of patent B are shown in the yellow or golden oval. And what this graphic shows is that the owner of patent A is able to manufacture and sell windshield wipers, which are protected by its patent. However, the area protected by the patent for the intermittent windshield wiper, the owner of patent A cannot practice that. The owner of patent A is blocked from practicing that which is shown in the yellow or golden oval. And what we also see is that the owner of patent B, its protection via patent B is within the scope of patent A. So this is actually a circumstance where the owner of patent B cannot practice its invention. And so the legal answer here is for the two parties to cross-license the various rights that they have, because the owner of patent A realizes that people are going to want the latest and the greatest, which is going to be the intermittent windshield wipers. And the owner of patent B understands that their improvement, innovation is still within the scope of the previously issued patent A. And so that is an example of the exclusive right, which brings us to some points about U.S. patents in general, U.S. patents in general. The first question being, well, why even bother with getting a patent? Patents are useful for supporting credibility of a company. Patents are useful for blocking competitors. There's a scare factor associated with patents. Having a patent portfolio allows you to have assets to license out to other companies. And I've even seen circumstances where a company just wants to reward employees. And so Johnny and Susie came up with this invention. The company gets a patent, and it names Johnny and Susie as inventors. And that's good for morale, good for the company. Regarding the patent system, the rules changed in 2013 significantly, and we are currently in a first-to-file system. Previously, it was a first-to-invent system, and so it's important to understand that while a version of the one-year grace period does exist in the United States, we are within a first-to-file system, and therefore it's beneficial to file as early as possible. Regarding the types of applications, we continue to have what we had before, provisional patent applications. The benefit of those is that they can kind of be thrown together quickly. They don't need to follow every letter of the law with regard to a formal patent application. The formal patent application being a non-provisional patent application. Those will have drawings that adhere to the drawing rules and regulations. The content of a non-provisional patent application must be according to rules, and the claims therein must be according to the rules as well. Now, it's important to understand that, while provisional patent applications do get put together quickly, they must still fully disclose the invention, how to make the invention, how to use the invention, and the other aspects in order to be a sufficient vehicle for the non-provisional patent application to claim priority to. With regard to timely filing, again, we're all waiting for the courts to chime in. The rules changed in 2013. Courts of law have not yet chimed in on every aspect of those rule changes. We believe there is a one-year grace period. Again, contact counsel regarding your specific sets of facts, because it's a very complicated, clumsily worded rule change. What we do know with regard to foreign rights is that most of the foreign countries worth getting into have an absolute novelty requirement, meaning that a patent application needs to be filed before the invention is disclosed in a non-confidential manner. And so the take-home message with regard to attempting to obtain patent protection is file early, and if you're in a larger company, be in touch with the research and development group so that you can get a patent lawyer on board and involved sooner rather than later. Regarding lab notebooks, they used to be, and they continue to be, but they were previously important because it was a first to invent system, and the lab notebooks would speak to timing of invention and those aspects. And so a question we often get is whether lab notebooks are still important. We're in a first to file system, and the short answer is yes, lab notebooks are still important. They provide information regarding not only details about the chronology of invention, but also what disclosures were made, and those are pieces of information that are important in the first to file system. With regard to a grace period, there's a circumstance where you can make a disclosure and then file a patent application subsequent to that. Having the lab notebooks, having other pieces of information that allow you to reach back in time regarding what was disclosed, who was it disclosed to, when was it disclosed, those are still important details that patent lawyers need. And finally, talking about preemptive disclosures, this is a situation where you may want to attempt to block a competitor who has not filed a patent application yet. So you make a disclosure of your invention X in order to prevent a competitor from successfully obtaining a patent on that. And then via the grace period, you would intend to circle back around and file your patent application on X within 1 year of that disclosure. Now, it's important to understand that an unintended consequence here might be a situation in which you disclose X, your competitor then sees an improvement and comes up with X prime, and then when you turn around subsequently and file your patent application on X, depending on the conduct of what the competitor did, if they made public disclosure of X prime or the like, that may well be prior art that is problematic to you. And so what we're saying here is, the preemptive disclosures, if you disclose X, you can turn around and file on X later, but be aware improvements such as X prime and the like may well be circumstances that end up being held against you during your patent prosecution. And so take a look here briefly at one of the questions. How will my company know if we can use our invention without getting into trouble? Well, good question, because we talked about patent rights being exclusive rights, which would mean that how will you know when you have the right to practice the invention? So when you go to an attorney with a new invention, they'll talk about a patentability search. And what that is doing is searching for documents, disclosures that may be considered prior art. The question then being, is the invention novel in view of the prior art? Is it non-obvious in view of the prior art? And just as a minimal threshold aspect, does the invention have utility? And so the answer to your question is that lawyers can perform searches and generate freedom to operate opinions. And that is the type of analysis in which the lawyer searches for issued patents and takes a look at the claim language of those patents in order to assess where your invention, where your technology fits in, to see if those existing patents are going to be problematic. Also take a look at those existing patents to make sure maintenance fees have been paid and that there are those are otherwise valid and could be something that could be problematic. So we're going to turn our attention now to trademarks. And trademarks, very, very briefly, are just source identifiers. They identify or distinguish your products, your services from the products and services of others. They may be words, Calvin Klein, they may be designs, symbols, they may be slogans. Colors can be trademarks, scents, and let's talk a little bit about packaging and store design. This really, if you've heard the term trade dress is what we're talking about. The way a package is put together, something that distinguishes it such that the consumer recognizes it as the particular product or service that the consumer is looking for. And there's a spectrum of trademark strength. And I talk to clients about this all the time because clients want a mark that tells what it is. The trademark lawyer comes in and says, well, wait a minute, the stronger marks are actually arbitrary or fanciful marks. And so an example of a generic mark would be use of the mark lens for your eyewear products. Okay, the term lens is generic for the lenses in the eyewear products. An example of a descriptive mark is National Bankers Association. That really describes, who's involved and what the services are. Suggestive marks are pretty good, area to be in terms of protectability. An example of a suggestive mark would be Speedy Bake in connection with frozen dough. Again, that the mark kind of being suggestive of what the product is. The arbitrary marks include examples such as Apple in connection with computers, Guess in connection with jeans, and then fanciful, the strongest position are really made up words. These are Pepsi and Kodak and Exxon and marks of those sort. So trademark rights come in different ways. They're unlike a patent. You really need to prepare and file a patent application in order to have patent rights result. And with regard to trademarks, you do, upon use of a mark, have certain rights that blossom. Those are common law rights which blossom. Independent and separate from that, there is value in obtaining a state trademark registration or a U.S. federal registration. Each state within the United States has a state system. There are some benefits associated with that. Typically, a state registration is obtained when use is local, meaning that there's not use in interstate commerce. The federal registration is obtained when you have use in interstate commerce, and really if you have use between two states or with a foreign country, the federal registration offers the most benefits. And this is so small I don't expect you to be able to read it, but the point is, when you obtain a federal trademark registration, you have the right to use Circle R as an indicator that you have a federal registration. Most importantly, you have the right to, you've got your mark in the trademark office database. And so that is going to be something that is found when trademark examiners are looking over future trademark applications. And that's just absolutely beneficial for companies in the future that really make an effort to look around as they should. They will find your registration in there. Now, going back to this slide, we've got the picture of the handcuffs there because it's important to understand that you have the right to police your mark. And the mark is a source identifier. It distinguishes your products, services from others. And so if there is another entity out there using your identical mark or using a confusingly similar mark, you have to police your rights and do something about that. With regard to strategic considerations, the first step when you come up with a new mark, when you start a company, is to perform trademark searching. And so the lawyer will be performing either a knockout, meaning basic type search, or a comprehensive search. And it just depends on what type of a mark it is. If it's a company name, you really want to look under all the rocks to make sure you don't stub your toe on anything. If it's a tagline that's only going to be used for a short period of time, that may be a circumstance where a knockout or basic search is more appropriate. Again, very fact dependent on the type of searching that's performed. With regard to applications, there are use-based applications, meaning that the trademark is already in use and you subsequently file the trademark application. There are also intent to use trademark applications, which are really beneficial. You can file the intent to use application, have an examiner look it over. The trademark office may issue a notice of allowance, and that really puts you in a position to start using the mark and have confidence that the trademark office has already looked at it and made a determination that things should be fine. So that's really a good tool to use when possible. I want to make a couple of comments about trademark portfolio management and domain name portfolio management. I want to point out that it's important to have a portfolio rather than just a single mark. And these two items are interrelated because if you have a primary product that is successful, if you have a service that's associated with a mark, just given the climate that we have in these days, someone is going to try to obtain a domain name including that mark in it. Someone may make a bogus Twitter account and post, questionable or damaging content. The same for Facebook and other social media platforms. And so really, it is absolutely beneficial to have a trademark registration in hand so that when you bump into somebody that's got, a .com that includes your mark, you bump into a Twitter account that's problematic, there are mechanisms out there to allow you to correct those problems, and having a U.S. trademark registration in place is really, really going to come through for you in those circumstances. And before we leave trademarks, let me take a look here to answer a question or two. My company is small and has budget limitations. How do I know which of my trademarks to register? Again, that's part of the business decision. If it's a name of a company, if it's one of your primary products, primary services, that's probably something that you would feel good about investing some money in. Again, if it's a mark that's going to be used only for a short period of time, if it is a tagline, those may fall to the side a little bit. Also, the type of mark, and what I mean by type, the strength of the mark is also an indicator here. I think that if you've got strong marks, fanciful, arbitrary marks, then you can, feel good about pursuing protection for those. Whereas if it's, merely a generic mark or descriptive mark, that may be a reason to not pursue a registration. Another question here. Since the Trademark Office database is public, can I search it on my own? And yes, you can absolutely search the public database on your own. The question becomes, what do you do, though, once you get the results? And the results that you obtain will need to be analyzed, and that's where an experienced trademark attorney is useful, because they have an appreciation for how close is too close. Let's say you search the Trademark Office database and you find some marks, having that experience to understand what is confusingly similar, what is not confusingly similar, understanding how, relatedness of products and services is really where the value of a trademark attorney comes through. So we'll turn our attention now to copyright. And with regard to copyright, we see that this is a form of protection which is provided for original works of authorship fixed in a tangible medium of expression. And we're going to break that down quickly. The work must be original, meaning that it's independently created and is at least minimally creative. If the work is not original, it does not qualify for copyright protection. And the work needs to be fixed in a tangible medium of expression. So that's going to be written on paper, captured in software code. Here are some examples of works that are regularly protected by copyright: architectural works, sculptural works, music, graphic works. And so that leaves us to the question, which works are not protected by copyright? And you'll see that these are really works that are protected by other aspects of intellectual property, right? Ideas, systems, methods, processes, these are things that patent law can really take care of. Slogans, marks, those are things that the trademark system can take care of. Book titles, you need to use a single mark in connection with multiple books in order to get trademark protection on it. That's a caveat. Book titles are cannot be copyrighted. The Copyright Office's position is that putting together 2 to 3, 4 words in a string lacks originality. That's not sufficiently original to warrant copyright protection. The protection provided by copyright law is that the copyright owner has the right to reproduce the copyrighted works, prepare derivative works, distribute the work, perform the work, display the work. And so if you are not the copyright owner and you're doing these things, that can be a problem. With regard to ownership and creation of a work, it's important to understand that ordinarily the author is the person that created the work. That said, if you're an employee or if you have a written agreement as an independent contractor, the employer, if you're an employee, and the party that has hired you on as an independent contractor, if that written agreement is in place, will be the owner of the copyrighted work. And so what we want to have an appreciation for is the work for hire doctrine, which says that even though an independent contractor created it, it is owned by the party that commissioned the independent contractor to take action. Again, very important to have the written instrument signed and in place before completion or before the work is created. There's a split in jurisdictions about this, but again, it's detail specific, but what I want to make sure you understand is that the written instrument for work made for hire is very, very important. Copyright registrations are available. It's not mandatory to obtain them. One of the more beneficial reasons for obtaining a copyright registration is that when the registration is made within 3 months after publication, again, specific time frame, or prior to an infringement of the work, statutory damages and attorney's fees will be available. So in litigation, there's often a question of, well, what are the damages and how do you prove the damages? And there are certainly some hoops to be jumped through. By obtaining the copyright registration, as outlined here, you have the opportunity for statutory damages, meaning damages by statute, damages by rule. So those damages will vary from $750 up to $30,000. And you can also have an opportunity to have attorney's fees covered. And so that is really a reason to take a look at this type of protection. Go to copyright.gov. That's the website for the Copyright Office. There's a lot of useful information there. And it is leads into my next point, which is copyright protection is cheap. It's cheap to obtain the registrations. Again, the protection is thin, meaning that if there is verbatim copying or if there is copying of substantial similarity, and we'll have an example here in the next couple of minutes of that, then that is a circumstance where copyright protection via copyright registration would be absolutely useful. And one practical point, just while we're on it, do not copy and paste from the internet. Some people think the internet is the wild, wild west, and it's really a situation that we have currently in that photographers are obtaining registrations of their work. They then scavenge the internet and they find somebody that is using their mark, using the photograph on a website or in a brochure or something like that. And then guess what? Litigation results, and oh, by the way, they've got the copyright registration, so they're looking for statutory damages as well as attorney's fees. And so, be very, very leery. In fact, your brochures, your internet content, it'd be a really good idea to have documentation on all of that, just so that you don't inadvertently hit a bump in the road. And so let's take a look at a copyright question here. How does fair use fit into copyright law? Well, that's a good question, and fair use is something that we hear a lot about. That is a situation, it's actually by statute. The copyright law says that the fair use of copyrighted work for criticism, comment, news reporting, teaching, scholarship, research, those types of activities is not an infringement of copyright. Well, that brings up the question, how do we know what qualifies for fair use? Well, the court determines whether a use is fair by looking at a couple of different factors. Number one, the purpose and character of the use of the work. Is the use commercial in nature? Is somebody profiting from that use? They also take a look at the nature of the copyrighted work. They'll take a look at the amount and substantiality of portions used of the copyrighted work. And they'll take a look at the effect of the use on the value of the copyrighted work. And it's, an analysis that a court undertakes. Recently, a lot of the decisions have really highlighted the first aspect we talked about, the purpose and character of the use. The court asks whether the use is transformative, meaning is it a new expression, new meaning, new message that results from the use. And what this brings to mind is the litigation that's going on right now between Authors Guild and Google. And this relates to the Google Book Project, which was started years ago. Basically, they're making digital scans of books that are in libraries. And so the Authors Guild said, well, wait a minute, you're copying verbatim the works how is that not copyright infringement? And Google has successfully, up through the appellate court so far, I think the Supreme Court is deciding whether to look at this or not, because the Authors Guild had appealed. Google's position is that the digital scanning is transformative, and it's a new expression, new way to use the information. Google's position is that the snippets that it offers don't replace the book. They don't substitute the purchase of they don't substitute for the purchase of the book, but those snippets merely serve to allow people to determine whether they want to purchase the books. And so, we'll see how this ultimately ends up. But this is an example of fair use, and Google has said, verbatim scanning, digital scanning of books is fair use based upon only the snippets of information it provides, and it causes little harm to the authors of the book, because at the end of the day, the person is really making a determination of whether they want to purchase the book or not. And if they do want to purchase the book, they'll still make that purchase, and they won't have everything that they need from Google. So with that said, we'll quickly turn to the last category. What is a trade secret? Trade secrets are information that derive independent economic value from not being generally known or readily available. And those pieces of information are subject to reasonable efforts to maintain secrecy. A lot of times, so what are some examples? Coca-Cola formula, Kentucky Fried Chicken recipe, things that are economically valuable that are kept secret. In order to keep something secret, it is necessary to have a trade secret policy. And trade secret policy, and it includes a lot of different things. And what we see is that it's going to be a circumstance where an employee leaves your company to go to another company, and the cause of action is going to be misappropriation of a trade secret. So first of all, was it in fact a trade secret? Was it something that was economically valuable? Was it something that was kept secret by reasonable efforts? And as we see on the screen here, confidentiality agreements, employment manuals outlining actions to be taken, marking products as confidential. These are the types of activities that result in something being considered a secret. You can use locks, keys, passwords, warning signs, exit interviews, making sure that when the person leaves employment that they understand that they've received confidential information, and they need to conduct themselves accordingly. And so, a recent example of this, in fact, is a situation where Amazon sued one of its veteran logistics executives who took a job at Target. Okay, so Amazon and Target both have an interest in moving, shipping goods in an effective manner across the country, and apparently Amazon has some specific ideas and trade secrets with regard to how a large company can do that. And so when this executive was hired by Target, Amazon filed suit indicating that, wait a minute, our concern at Amazon is that some of our trade secrets are going to be misappropriated. Okay, so again, the scope of trademark trade secret protection is that you're going to have key employee that joins the competitor across the street, and the question is whether those are the result will be trade secrets being misappropriated. Big companies versus small companies. Big companies will have the procedures in place, the policy in place. As a small company, if you intend to rely on trade secrecy, then you want to make sure that you've got a policy in place. Okay, so let's circle around and take a quick look at some of the risks. If you've started a company and you really weren't aware of the strategy to be employed with regard to intellectual property, or maybe your strategy has just been it's not worth the trouble, we really need to take a look at some of the risks that result from that. As we learned, missed opportunities in patent law. If there are certain circumstances where if you don't timely file the application, your rights are lost forever and ever. Being less than properly positioned for success. Let's take a look at common law trademark rights as opposed to the position you're in if you have a U.S. federal trademark registration. Let's take a look at copyright. If you have a copyright registration, statutory damages, attorney's fees. These are all types of things that will properly position you. And then, you can avoid having to pay more later to clean up a mess. And specifically, what comes to mind are the social media platforms, the failure to obtain a portfolio of domain name registrations. If you don't have a trademark registration in place and somebody captures some domain name registrations you were interested in, cleaning these types of things up after the fact are oftentimes much more expensive than it would have been just to handle it properly on the front end. And so in closing, I want to take maybe another 5 or 6 minutes to talk through, what can we do now for your intellectual property? Your intellectual property is valuable, and I think it's a circumstance where you could view it as what's shown on the screen are seeds, and you need to nourish and nurture the seed in order for it to blossom into what it can become. And so with regard to steps to be taken towards obtaining a noteworthy intellectual property portfolio, the first thing we need to do is to identify our best practices for identifying our intellectual property assets. And then once we have identified those intellectual property assets, we need to have an awareness of which is the best mechanism for protecting those aspects. And then we also want to be cognizant of the intellectual property rights of others. We don't want a situation in which we inadvertently step on the toes of someone else. And finally, what I want to talk about are intellectual property myths. And in fact, I'll address those right now. We've already learned today that the myth that I patented it, therefore I can do it, is just not correct. The patent protection allows you to exclude others from certain conduct. Just because you patent it doesn't mean you can actually practice it. Another myth, I paid for it, so I own it. Well, do you have the work for hire agreement in place? And everybody's got websites these days. You should have an agreement with your website developer. You should have an agreement with the people that are generating the content for your website. Just because you paid for it doesn't mean you own it. You have to have those work for hire agreements in place in order to solidify ownership. Another myth, patents, trademarks, copyrights, and trade secrets are all interchangeable. Well, no, they're not, and hopefully what we've learned today is that they each have a role. And so patents are useful in certain circumstances, trademarks are useful in other circumstances, and so we need to know which protection to employ for a given situation. And another myth that I often hear is, well, I can get protection later. Well, again, with regard to patents, if you delay, you might inadvertently lose rights. Again, with regard to obtaining a copyright registration, if you do that after someone's already infringing, then maybe you're not as well positioned as you could have been. So these are some of the myths that are out there, and we want to address. I've got a couple of questions on the screen you can take a look at. Those are in your materials. Really just questions to ask yourself with regard to how to identify intellectual property assets. It might be a circumstance where you are just not aware of some important intellectual property that you have right now. And so ask yourself these questions and really consider the answers. Also, with regard to best practices for protecting intellectual property assets, filing patent applications for inventions is good. Registering trademarks and copyrights, keeping those trade secrets actually as secrets, using watch notice services. As a law firm, we can set up notices to capture publicly available information. When a patent issues, what patents do your competitors have? When a trademark application publishes, if are there applications, trademark applications that publish that are arguably confusingly similar to your registration? We can identify those before those even become registrations. And so there are a lot of tools out there allowing us to watch the conduct and activities of your competitors. Also, keep in mind negotiating agreements with your business partners. When there's a circumstance in which intellectual property may result, who owns it, who has the rights to use it. These are all important questions, and these are things that your agreements with your business partners need to take into account. And I put a picture of a crystal ball on this slide because I understand everybody has a budget, and you can't, in all likelihood, chase everything that you would want to do, and so given budget constraints and the like. And so that's part of the magic of business, identifying what to pursue and what not to pursue. Once you have protection in place, it's very, very important to make sure that you're giving notice using proper markings. We don't have time to go into all the details, but it can absolutely impact your ability to obtain damages and amount of damages. And so for a U.S. patent, this on the screen is the type of a notice that you would give. Federally registered marks, we use Circle R. Non-federally registered marks, we use TM. Ownership notice for copyright is the copyright symbol, date of publication with the name of the copyright owner. Best practices for avoiding the stepping on the toes of others, perform appropriate clearance searching, and that's going to be a circumstance, and we've talked about today, that we can search patents, trademarks, we can search Copyright Office. These are the types of activities that you want to make sure are undertaken. Training of employees to avoid common pitfalls. Do not copy and paste things from the internet. It's just not a safe environment to do that these days. Having policies and guidelines to reduce infringement risks are some of the things we've talked through as well. Also, very important to keep an eye on your competition. And Google Patents is available. The Trademark Office has a public database. You can take a look at what your competitors are up to. Maybe that would give you an advantage in terms of what their strategies are and what direction they might be going. And so another question that often comes up is, what number of patents should my company have? And we'll go through this very quickly. It really depends on your business goals, your exit strategy. With regard to business goals, do you want to box in one of your competitors? Do you want to sell the company in a year? These are the types of things that are related to business goals, exit strategy. Which industry are you in? Absolutely, high technology industries are industries in which there are many patents, and also it's important to be aware of what your competitors are up to. Do you have competitors that have large portfolios of patents? And so these are all questions to ask in order to consider the number of patents that your company should have. Very briefly then, when is the state trademark registration sufficient? Federal registration requires use in interstate commerce, and so that is going to be a situation in which the mark is in use between multiple states or with a foreign country. And if you do not have use in interstate commerce, you would have local use. So that might be just within your city and not beyond the boundaries of your state. That's going to be local use. That's when a state trademark registration system is really a good fit for a protection of a mark like that. So how about the future of intellectual property assets? How are things going to change? What can we do to best position ourselves? Will there be changes to the rules for obtaining intellectual property? Probably. 2013, there was a big change with the American Invents Act, and we're still interpreting the meaning of that and what the consequences of that are. Will there be changes in the manner of IP enforcement? Probably. Certainly a part of the American Invents Act was the post-grant review. It's a circumstance where you can file get this proceeding started within 9 months of the grant of a patent in order to take a look at how that patent would be interpreted and with regard to validity and the like. And so, that is a mechanism that came out of the fact that patent litigation is, very, very, very expensive. So it would make sense to have another mechanism that those within industry could make use of to figure out where they stand in the patent landscape. How will you promote your products and services in the future? Previously there was not a Twitter, previously there was not an internet, and so what's next? There's going to be something similar to that. And then what barriers of entry might there be in the future? 30 years ago, really before the internet, it was necessary to have brick and mortar. If you were selling a product or offering services, oftentimes you needed to have a brick and mortar location. And now there's a bunch of companies that have a website, and that's how they market their goods and they ship their goods to their clients. How will your customers pay for products and services? And, this is interesting because I bumped into a patent application recently in which just the manner of making payment for an item is going to change. There's a patent application pending that was published for the steps of taking a selfie. What do we do when we pay for things right now? We pull out our credit card and provide it to the retailer. Maybe a situation in the future where we just take a picture of ourselves, and then there's a database where that picture is linked to our credit information or contact information such that payment can be made just by taking a selfie. So, these are circumstances where the future is going to be changing, and we need to be aware of what those changes might be. So I thank you for your attention today. I did run a little bit long. Actually, let me take a look here at the closing slide. If you have any questions, here's my contact information. Absolutely feel free to reach out to me. I appreciate the many people that participated in the seminar and the webinar. I will address, I understand if you have to depart, but I will address a couple of questions here real quick. How long does each type of protection last? Is any maintenance required? And so that's a good question, and the answer is that it depends on the type of protection. Patent protection, if it's an application that was filed after 1995, lasts for 20 years from the filing date. There are maintenance fees that are due at 3.5, 7.5, and 11.5 years in order to keep the patent valid. Trademark registrations, U.S. federal trademark registrations, those have a maintenance step at the 5-year mark. Between the 5th and 6th year, it's necessary to file a declaration of continued use to show that the mark is still in use. And then the trademark registrations can be renewed every 10 years. And so trademark protection is really a protection that could go on indefinitely. Very quickly, copyright registrations. Those are typically the life of the author plus 70 years. If it's a work for hire, if it's a published work, I believe that's going to be 95 years after publication. But again, copyright.gov has just very user-friendly website, and it's a situation that they've got a lot of useful information as well. One last question, and then we'll wrap it up. See what we've got here. I'm building a company with a couple of friends. Do I really need all of the paperwork in place on the front end? That's a great question. And as a lawyer, in view of all of this information that we've learned today, I think you really need to. I think it's friendship is valuable, and I've certainly seen business situations done on this, on a handshake. But certainly, growing a company, building a company that ultimately maybe another entity would purchase, the purchaser is not going to buy a lawsuit, and they are going to want things buttoned up. And so the more you can do on the front end to show that you own the intellectual property and all of the proper documentation is in place, those are not going to be negotiation chips or bargaining chips that a purchaser would use to devalue or decrease the amount of the sale price. So thank you again. Sorry that we ran a little long. Again, do go to fpttech.com. This webinar will be posted there, and the couple of prior webinars have already been posted, as well as a lot of interesting and trending content related to law and technology. Thank you.